Thank you all for joining. We will get started in just a minute as we continue to let attendees join the call. Thank you for joining again and welcome to this Hastings Center webinar. While you are not audible or visible, we encourage you to ask questions through the Q&A function. And this session is being recorded and will be available at the Hastings Center website later today. And now I would like to turn to Dr. Mildred Solomon, the president of the Hastings Center.
Hello, everybody. And welcome to this, our second webinar related to the Dobbs decision. In Dobbs v. Jackson Women's Health Organization, the U.S. Supreme Court undid the Roe v. Wade decision, which had recognized a right of privacy and defined the decision to continue a pregnancy or not as a private matter. Instead, the court held that the U.S. Constitution does not protect that right and gave that decision to the states. Many states have developed highly restrictive laws. So far, 12 have enacted outright bans on abortion. Currently, 9 provide no exemptions for rape or incest. In addition, as reported in the New York Times just yesterday, in an opinion piece by our very own Hastings Fellow and Hastings trustee, Michelle Goodwin, we are now seeing states prohibiting third parties, including relatives, friends, healthcare providers, even librarians, from sharing information with persons seeking abortions. Efforts are afoot in several states to stop the communication of information about which states are providing legally permissible abortion services, and information on how to access abortion medicines is also being suppressed. Justice Alito wrote the majority opinion in Dobbs, and a great deal has already been written and discussed about his argument and its limitations. But today in this Hastings Conversation, we have the great pleasure of hearing from Anita Allen. Professor Allen is a University of Pennsylvania professor of law, professor of philosophy, bioethicist, a renowned author, and an international expert on privacy. She is going to describe each of Alito's arguments and then offer her own unique critique, including important commentary she presented at Oxford University in the UK recently. So I'm going to ask Professor Allen to turn her camera on now. Hello, Anita.
Hello.
Hi. Thank you so much for participating in this webinar. And now it's my job to embarrass you by talking about you in the third person for just a moment or two. I'd really like our audience to understand more about your background.
Okay, I will suffer through this.
Okay, thanks. Professor Allen holds both a PhD in philosophy from the University of Michigan and a JD from Harvard Law School. She's made noteworthy contributions, not only in law and philosophy, but also to their practical application in medicine, science, and public policy. In 1998, Professor Allen joined the faculty at the University of Pennsylvania, where she is now the Henry Silverman Professor of Law and Professor of Philosophy, and a major intellectual figure across the university, where she plays many, many different roles. She served as Vice Provost for faculty from 2013 to 2020, and she's been a Senior Fellow in the Bioethics Department at the medical school and a collaborating faculty member in Africana Studies, and an affiliated faculty member in Gender, Sexuality, and Women's Studies, and several other important roles in other parts of the university. At NIH, she served on the National Advisory Committee for Human Genome Research and on the IRB of the National Institute of Health's All of Us program. She was appointed by President Obama to the last Presidential Commission for the Study of Bioethical Issues. She's an elected member of the National Academy of Medicine and the American Law Institute and a fellow of the American Academy of Arts and Sciences. And I would be terribly remiss not to mention that she is a fellow of the Hastings Center and has served on the Hastings Center's board from 2007 to 2011. And the Hastings Center recently bestowed our most prestigious award, the Bioethics Founders Award, on Professor Allen. It's the highest honor that we give for extraordinary scholarly achievement. So that's probably enough, Anita. I should stop. I could go on and on. I've asked Professor Allen to start us off with some opening remarks for just a few minutes. And then she and I are going to have a conversation. And then we are going to open the floor to questions from the audience. As a reminder, we're not using the chat function. Instead, please put your questions into the Q&A function. So let's get started. Anita, how should we begin to think about what is going on with respect to reproductive rights in the United States? Can you set the stage for us in any way you'd like? Give us a frame.
Thank you. Thank you. So I think I'd like to use as my opening frame a framework that I've used in the Encyclopedia of Bioethics, 2 editions, to describe global abortion regulation. It seems to me that prior to the overturning of Roe versus Wade, that one might say there are 4 major models of abortion regulation globally. They all begin with a P: the model of privacy, the model of permission, the model of prohibition, and the model of prescription. The model of privacy used to be exemplified by the United States and by Canada, where women can readily obtain medically safe abortions without having to give a reason or justification to the government or their physicians. The model of permission, which is pervasive in Europe, is a model where abortion is quite available, but there's still a requirement that a woman cite one of several permissible reasons for the abortion, those reasons including rape, incest, health, economic hardship, or family hardship. The model of prohibition, which is present in some countries in Central South America, used to be prevalent used to be in effect in Ireland, although it no longer is. The model of prohibition is a jurisdiction where basically most or all abortions are prohibited by law. And then finally, the model of prescription would be a jurisdiction of which I think maybe China, under the one-child policy, is my only example of a country where because childbirth is strongly discouraged, women must obtain abortions in order to avoid penalty or punishment. So that was the scenario before Roe was overturned. Now what's happened is America is not a model of privacy anymore, because on the federal level there is no right to abortion, but it's a combination of models of prescription, models of prohibition, models of permission. And so looking state by state, we can take my 4-part sort of analysis and ask ourselves, okay, in this jurisdiction, in Mississippi, what is it? Well, maybe it looks like a model of prohibition. What is it in Georgia? It might look like a model of permission. But the relevance of all of this is that, in effect, the rights that women have had to obtain medically safe abortions has devolved. It's devolved in 2 senses. It's devolved from the federal government to the state level. It's also devolved in the sense of now we've taken a step backwards, and women no longer have the freedoms and the opportunities they had before to exercise control over their reproductive capacities. One of the things you didn't mention in my bio, Millie, and you might not even know this, is that I was during the 1990s briefly on the National Board of Planned Parenthood based in New York, but more significantly to me, because it was more to my heart, I was on the board of the Planned Parenthood of Metropolitan Washington, and I was the chair of the board of Planned Parenthood of Metropolitan Washington for several years. So I was like in the trenches, on the ground. Our affiliate had 6 clinics throughout the Washington, D.C. And suburban areas, and we performed abortions, but also just general sexual health, reproductive health services for the community. So I've seen the abortion right on the ground functioning well. I've also seen the threats, obviously the legal threats that have been issued over time, and now we're in the situation that we're going to talk about today.
I didn't know that about you. So thank you for bringing that in. That's lived experience that really matters. Now, I know that I'm talking to you now really with your legal scholar hat. I know that Alito made 5 claims in his decision. And I was wondering if we could just start off maybe creating a level playing field so everybody kind of knows what his argument was, just briefly. And then I'm going to ask you after that to unpack each one in more detail. So could you sort of quickly lay out what those 5 were?
Yes. So one of Alito's argument is that there is no enumerated right to abortion in the Constitution. It's not a textually grounded right. That's number one. Number two, there are some exceptions. There are rights that are not enumerated, which are still important constitutional rights, but abortion rights do not qualify under any exception for fundamental rights. They're neither deeply rooted in our nation's history and traditions, nor are they implicit in the concept of ordered liberty. That's number two. Number three is that because of number one and number two, the Roe versus Wade decision, which purported to find a constitutional right to abortion, was flawed. It was an unprincipled decision, an unprincipled results-oriented decision. That was number three. Number four, Roe versus Wade and Planned Parenthood versus Casey, which was decided in 1992, and did permit some restrictions on abortion, but also held that the abortion right could not be unduly burdened by legitimate state laws. Abortion law is unworkable, and it just hasn't worked. Was his claim, which is we'll get into that a little bit later, but that's unworkable. Then he argued that abortion rights upheld in Roe need not be sustained, although the principle of stare decisis, which gives us a bias in favor of sticking to established law, is an important standard. It's not an absolute standard, and where a decision is patently wrong, as he believes, Alito believes the Roe decision was, the courts need not stay behind it. And then finally, this is maybe more of a perspective than an argument he made, but he does end his opinion by emphasizing that, in his view, abortion is a moral matter that should be best left to the people through democratic processes. So if states want to ban some or all abortions because of the moral views of its polity, the state then has a right to do that. So that's in brief a sort of an overview of the landscape of arguments that Justice Alito made in the opinion.
Thank you. Now, I know a lot has been written and discussed about these 5 points, but you have, I think, a unique perspective on it, given your expertise in privacy and other aspects of your scholarship. So could you now take up each of those and give us your take on their validity?
Well, as you know, we only have an hour. And so I'm not going to be able to go into each one in detail, but let me just maybe say a couple of things about some of the ones that I think are most important and most troubling. The claim that the abortion right is not an enumerated right strikes me as either just simply wrong, or as wrong in a silly kind of way, because almost none of our constitutional rights are enumerated expressly in the Constitution. So that abortion rights are not there in black and white in a document that was drafted in the 18th century. It's not even an interesting point. It's just, of course, it's not. How do we really do constitutional law? So I think that first point about it being unenumerated, it reflects a textualist philosophy of jurisprudence that really cannot be defended by serious constitutional scholarly arguments, in my opinion. The argument he makes about there being no exception for abortion, that abortion is not a fundamental right because it's not deeply rooted and not included in the concept of ordered liberty, is among, for me, the most critical arguments he makes, because past abortion cases have found that abortion rights are indeed deeply rooted in our nation's history and tradition and implicit in the concept of ordered liberty. The deeply rooted point. Here, you have to be a historian to really excavate, what's part of our nation's history. And the historians that I admire the most, those who come at this issue from the point of view of women's history, from the point of view of feminist history, from the point of view of just, I think, sound constitutional theory, they emphasize that at the time of the founding, there were no laws that prohibited women from obtaining an abortion, and that in fact matters around birth control, childbirth, and abortion were pretty much left to families. And so there was no historical ban against abortion rights, as I think the Alito opinion seems to suggest. But even if it were the case that abortion is not deeply rooted in our nation's history and tradition, because it was not a practice that was sanctioned implicitly through culture or convention in the past. I do think that the idea that a robust, modern conception of liberty would not include control over your reproductive capacities is not a strong argument. That the stronger argument is that, yes, liberty in a democracy that is well ordered, where men and women have control over many aspects of their reproductive and sexual capacities, is, I think, a perspective that could overcome the position that Alito offers. Plus, this whole idea of this two-part test: is it deeply rooted, and/or is it ordered liberty? That comes from some precedents, case law. It doesn't come from any statute or that sort. So it comes from case law. And I think one could probe that case law to see what was going on in that case law and whether or not this important right should, under the test as articulated in that case law, can be defended. The unworkable point, I mentioned in my opening that when I was a board member at Planned Parenthood, we ran 6 clinics, and some of them performed abortion, some of them did primary care, some of them did STD, some of them saw male patients, some of them saw male and female patients. And so I literally don't understand the argument that Roe versus Wade has proven to be unworkable. What Alito turns to try to make his point is to say that the jurisprudence of Casey and Roe has proven unworkable, meaning that in the courts there's been some disagreement about what's unduly burdensome and what should be the proper dividing line between permissible and unpermissible abortions. But it seems to me that just because judges and even state lawmakers have some disagreements doesn't mean that the provision of health care to women and their families is not working. It's working. It had been working, I think, quite well, meaning very little mortality and morbidity associated with medically safe abortions, whether surgical or medical. And then I'll just say one more thing before we move on, and that is this idea that it's a moral issue that should be returned to the states. When I first read that argument, what came to my mind was the image of January 6th, with all those people crawling up the walls of the Capitol, trying to get into the Capitol to overturn the election. Unfortunately, when we think about raw democracy today, that image is all too appropriate. We have to ask ourselves, which of the rights and prerogatives of citizens should be left to democratic processes, and which one should be protected by federal and constitutional law? I really like the argument that Larry Tribe, an old liberal, made many years ago, that no matter where a woman lives in America, she should know that her rights are protected, that she has the same rights, no matter where she lives. And think about it today, Millie. A young woman could be, say, a college student in Massachusetts. Her family home could be in Georgia, and she might have a summer job in Dallas, Texas. What are her abortion rights? Think how difficult it is for her to determine what her abortion rights are. If it's a moral issue, does that mean that it should be left to the almost sort of randomly devolved set of state laws that we have. It's very confusing. I think abortion law today is in disarray, and that does not serve women's health at all well. And I think that we really need to not allow the moral character of the abortion decision to say, let the state legislatures decide, no matter what's going on in the country as far as our democracy is concerned. Instead, I think we should ask ourselves, what would it mean to give women, as individuals, the choice to make their own moral decisions about something that's so close to their bodies and their lives? I think that's where the moral argument points us towards Roe versus Wade, towards giving the choice to individuals, so each person, each family can make their own decisions about right and wrong and what's in their interest, not a raw majority that may not have the best interest of women at heart.
In pointing out what can happen through legislative action or through popular voting, for example, you're kind of bringing attention to the very function of the courts, as I understand them, which is to protect individual rights. So, I mean, isn't the judiciary a part of our system to make sure that we are protecting individual human rights that may be lost in popular clamor that you can get from a legislative remedy, where the majority rule may run roughshod over self-determination and individualism?
Yes, and I mean, this is not an easy issue, right? But the whole idea of human rights and civil rights and fundamental constitutional rights is that there are certain rights and privileges which really should not be left to democratic processes. It isn't that they're completely undemocratic, because our nation, we have a social contract that is the foundation of our democracy. But still, we don't want to leave certain kinds of choices to the majorities. For example, I mean, would I be sitting here talking to you today if we had not been able to pass civil rights laws that required that people respect Black people by letting them into places of public accommodation, giving them voting rights, giving us the right to affirmative action in education? A lot of the rights that a lot of Americans treasure, Americans of any color treasure, are civil rights and human rights that are enshrined in statutes or in constitutional doctrines that help us to live a life that's actually safe and free. And we need that in any kind of plausible liberal democracy.
I know that many people have felt that Roe was wrongly argued, that a constitutional right to abortion should not have been argued on the basis of privacy, but rather on liberty or equality. And it seems you disagree, and you believe that do you believe that privacy was correct? And what were your thoughts about this originally, about the decision being based on privacy? And have your thoughts about it changed now that Roe has been overturned?
Thank you. My views have not changed now that Roe's been overturned. Jack Balkin, who's a law professor at Yale, published a book that's a series of mock opinions called What Roe versus Wade Should Have Said. And he asked a number of legal scholars to rewrite the Roe opinion as if we the authors had been alive and well and on the court in 1972. So, and we were only allowed to use materials that were available to the court in 1972. 73. So in my opinion, my rewriting of Roe versus Wade, I make a strong privacy argument, which is a liberty argument, essentially, the argument that there should be freedom of choice regarding abortion, grounded in the 14th Amendment due process clause. But I also make an equal protection argument. I make an equality argument grounded in the equal protection clause, that women, like men, deserve the opportunity to exercise important choices over whether and when they become parents. I make a further equality argument based on equal citizenship that I would also ground in the 14th Amendment, that the character of citizenship that women enjoy is not on par with the quality and character of citizenship that men enjoy, unless women can have access to reproductive choices, because those choices ground a lot of women's economic and social potential, their ability to go to school, to finish school, to get good jobs, to become professionals. And at the time that Roe versus Wade was written, this was a particularly important point, because women were still at that time radically overrepresented in the fields of teaching, nursing, home care, janitorial work, and so forth. So we really need this idea of citizenship equality, I think, to partly to help to explain why Roe is so important. So that would be my response. I think even today it's a mistake to say, oh, if only Roe had been argued on equality grounds. That to me is not a very plausible argument. Why? Because if you go back and look at Supreme Court equal protection jurisprudence from the 1970s, there is no indication whatsoever that our courts were prepared to say that women should have the same access to citizenship, or the same access to liberty that men have. That just wasn't part of the conversation. There was no equal protection jurisprudence in place at the time to really undergird that argument. Plus, I would emphasize, from talking to abortion rights advocates who were on the ground in the trenches back in the 1960s and 70s, the privacy argument was the conservative argument, because that's the one that the privacy of marriage and families and the home requires that we stay away from the abortion decision and the birth control decision, whereas the equality argument was asking society to do something that it never done before, which is to assert the moral and legal and political equality of women. So I think that the privacy argument was quite wise. It had some consequences that are interesting we can talk about, but I don't think we can blame the failure of Roe versus Wade on the privacy argument. We should blame the failure of Roe versus Wade, insofar as it's been a failure, on the will of some activists and legislators and judges to bring Roe to its knees, which it did Justice Alito did in the Dobbs opinion.
On this privacy point, I've often thought that privacy was a mid-level value as opposed to a foundational principle. Mid-level, I mean, in the sense that cultures can differ in how they view privacy without violating any important ethical norms. I remember a striking example in one of Ruth Macklin's books where she talked about how it was perfectly normal in a certain country to post the expected dates of women's workers' menstrual cycles on the wall, because that was thought to be pertinent to who would do what tasks. I mean, that would be shocking in the United States, but it's not necessarily an ethical violation. What makes our differing privacy customs more than just customs or cultural preferences? Or let me put it the other way, what makes privacy a foundational right?
So in all of the books that I've written about privacy, uneasy access, privacy for women in a free society, why privacy isn't everything, feminist reflections on accountability, and in the book Unpopular Privacy, which is the most recent one, I do try to make the case that privacy is not like ice cream and fast cars, an optional good.
Okay.
And people who think of it that way think that it's really, up to you whether you enjoy privacy or not. It doesn't matter, because I think it does matter. I think that opportunities for meaningful privacy and private choice ground a life of flourishing and value, and that both for individual self-fulfillment, self-development, and self-respect, we need to promote privacy. But also, I think that in order for us to be the kinds of people who in a social context are fit for their social responsibilities, we need opportunities for privacy and private choice. And just to explain what I mean by that, I mean, I don't know, I had 2 kids and I raised 2 small children, and I believe that the opportunities for privacy and private choice that I had as a modern American woman enabled me to be a better mom and a better citizen. I was more refreshed and had more time and more energy for things like being on boards and teaching law and taking care of my family. My social contributions were greater because there was a reserve of privacy in my life that was the foundation of my self-awareness, self-definition, and repose. So I think it's such an important value, and it's important to me in the way that freedom itself is important. In the first U.S. state court to find that there's a right to privacy. The judge, this is Judge Andrew Jackson Cobb in a case called Passers versus New England Life Insurance Company from 1906, I believe, in the state of Georgia. In this case, the Judge Cobb said that when someone violates someone else's privacy, they are like, to that extent, slaves of a merciless master. And I thought, wow, even in the beginning of the 20th century, a Southern judge could appreciate the extent to which denying someone the ability to withdraw from society for periods of time and certain purposes was an important value, so important that not having it would be similar to what we experience in terms of the horrors of chattel slavery. And this particular judge was the grandson of slave owners, the son of slave owners, and the nephew of slave owners. His uncle actually wrote the Constitution of the Confederacy. And so for this particular judge, only 40 years after the end of slavery, to invoke the idea that privacy invasions are comparable to degrees of enslavement is really a profound point that I go to again and again in my thinking about why privacy is such an important value. We need the ability to make key choices about our own bodies and our own lives. We need to be able to seclude ourselves and experience solitude and other aspects of privacy, anonymity, confidentiality, et cetera, in many domains of our lives.
I know that at some point your views have gotten into tension or differences with other feminists. And I think it would be very useful for you to kind of help bring our audience along. What were the feminist arguments against privacy, and where did you stand in relationship to those?
Well, in the 1980s, Catherine McKinnon was a very influential legal feminist, and she argued that the right to privacy that's offered through the Roe decision is a useless right to women because, as she put it, the right of men to oppress women one at a time. And I really get what she meant, but I disagreed. There's no question but that the concept of privacy has done all kinds of evil in American society, going back to the famous case of State versus Mann, where an enslaved woman was shot and wounded by a man who had hired her out from her owner. When the court asked the question, well, can this white man be criminally prosecuted for shooting this enslaved woman? The court said no, on account of the privacy of the master-servant relationship. Wow. And then a few years later, she survived. But the point being that that actually in this case, what was so fascinating is that the white people of North Carolina criminally prosecuted the man for shooting the slave for a trivial reason. But then the man appealed, and he won on appeal. The judge in question was a slave owner, perhaps unsurprisingly, but he defended the idea that the privacy of the master-slave relationship and the importance of not undermining that relationship was a reason to not allow the state to criminally punish someone who shot a slave. And then in another case a few years later, same thing happened when a white woman who'd been beaten by her husband sued and wanted to have her husband prosecuted, but the court said, oh, the privacy of marriage and family life prohibits us from interfering with such trivial violations of the law, like beating your wife. So we've seen as women and as people of color, we've seen privacy do bad things. And so I'm not unsympathetic to the view that Catherine McKinnon and other feminists have posed, that privacy is an anti-feminist value. I think privacy is not an anti-feminist value. I think everybody can enjoy and benefit from opportunities of privacy and private choice. And in fact, after she encountered some of my work, Catherine McKinnon herself softened her view and said, oh yes, well, of course, as Anita Allen points out, there can be some beneficial uses of privacy. But so I think she and I agree on the history of the thing, but we disagree on whether in the modern time, in contemporary time, there's still a place for a robust privacy discourse. I think there still is. But other people have also diminished the privacy argument. It's a whole literature trashing the privacy argument, not just the feminist literature, but there's a non-feminist literature trashing the privacy argument in favor of ideals like toleration, or equality or anti-conscription. But I think all these ideas to me work together. Instead of saying it's this or that, I think that there's a whole rafter of important liberal values that can be brought to bear on the abortion decision.
Well, another important liberal value is freedom of speech. And I invoked Professor Michelle Goodwin in my introduction because I was very impressed with an opinion piece that was published in the New York Times yesterday, in which she was first author, and pointing out that for years, those who have been against the legalization of abortion claimed free speech rights to speak and act to curtail abortion services. But now they are dramatically eroding freedom of speech for others by making it illegal to even share information about where abortions are legal or about how to access abortion medicines. What do you think about what's going on with the use of our freedom of speech arguments? And
yeah, and I've experienced what you're talking about firsthand, because in my life as a Planned Parenthood board member, we had to face the question of how do we respect the free speech rights of abortion activists, anti-abortion activists. We respected the fact that they had a right to protest outside of our clinics, and the courts established a distance from the patients that was required in order for those free speech rights to be reasonably exercised. I myself was verbally harassed by abortion protesters. I remember one day I was walking into Planned Parenthood, which is located, by the way, right on 16th Street, only about 4 blocks from the White House. But this person said to me, "Don't go in there, young woman. They're trying to destroy the black race." And so for this, white abortion protester to be telling me that inside the headquarters of Planned Parenthood of Washington, they're trying to destroy the black race was at the time for me deeply upsetting. Nonetheless, I respected the First Amendment rights of those folks to be out there making their points. Okay, so yes, Michelle Goodwin and her co-author are exactly right. There's this irony now that whereas before anti-abortion activists were claiming First Amendment rights to protest outside of doctors' homes, outside of clinics, all over the place, to publish and to speak as they saw fit. And now it seems the opposite's happening, where they're asking us to shut up about abortion and to not talk about it, to not talk about services and opportunities to receive a pregnancy termination procedure. But I think I want to point out something that Michelle and her co-author didn't point out, which is that there's nothing new though about this contradiction. There's a case called Russ versus Sullivan in which the abortion gag rule was debated by the Supreme Court. Can government-affiliated doctors be instructed by their government employers to not talk about abortion? Answer: yes, they can. So gag rules have been upheld by the Supreme Court. And remember the case of Eisenstadt versus Baird, which was a case that found that unmarried people as well as married people could use birth control. That was a free speech case in which the abortion activists wanted to shut up a doctor. But in that case, the Supreme Court said, no, the doctor may discuss birth control and may even give birth control to an unmarried person. But we've had this tug of war between free speech and abortion rights for a long time. It's now become extremely grave because it seems as though the Dobbs decision gives the states the right to really meddle with free speech far more extensively than we've ever seen before. And this is, to me, one of the biggest threats to American freedom concerning abortion that we have to deal with right now. I mean, it can't be the case that moms should be prosecuted for talking to their daughters about abortion rights, that clinics should not be able to advise women about legal abortions and about how to get them. That can't be right. And I've been shocked before lately, but I would be especially shocked if our federal courts as a whole upheld the ability of states to gag families and clinics so extensively as this current legislation seems to be attempting to do.
Thank you for that answer, Anita. I know we have questions that are in the Q&A now, and Ashna has been looking at them. So Ashna, do you want to join us and relay some of the questions from the audience?
Sure. So one major theme in the questions has been about the role of physicians in addressing the Dobbs fallout. So one attendee asks if you can comment on Dr. Matt Winia's New England Journal of Medicine piece discussing physicians' civil disobedience in response to Dobbs. And a related question asks that besides condemning Dobbs, as most medical societies have already done, what else should physicians be doing, either collectively or individually?
Anita, if you're not aware of Matt's piece, I'm happy to summarize it for you.
Maybe you could summarize it, but I mean, I have some general remarks to make. But so maybe make the general remarks first, and then you can tell me if I'm responding to Mark's article, which I've not had a chance to read yet. I am extremely in awe of physicians who have stuck with the abortion rights movement and who are providing abortion services for the women who want them and who need them. So in awe. But I'm also a little bit uncomfortable with the idea that physicians should feel morally obligated to engage in civil disobedience, placing their safety as well as their medical license, state medical license on the line. I think that we can ask too much of our healthcare providers, right? And I just feel cautious about that. I admire a physician who stands firm and seeks to provide a medical procedure that is safe and they know it's safe to a patient. But I also don't want to see our doctors carted off in chains and put in jail for disobeying state laws. So I would like to say it would be, to me, a last resort that doctors would feel morally compelled or be morally compelled to engage in acts of civil disobedience. But it is serious. I mean, we're talking about a serious deprivation of a medical service, and in a country where women can get their breasts enlarged and their noses made pointier and their eyelids lifted, that they can't get a medically safe abortion is ridiculous. And so the contradiction between the respect we show some doctors and the disrespect we show others, the respect we show to plastic surgeons who perform dangerous and completely unnecessary procedures, the disrespect we have for doctors who are trying to help women get control over their bodies and lives and protect their families. It's a contradiction that's very hard to live with. So, Millie, what does the
article... That was just a fantastic answer. I'll just pick up the second half of the question, which is what can doctors do, and maybe put a gloss on Matt's piece. He was acknowledging, I don't think he was calling on people. No, we had him on an earlier webinar, so people can judge for themselves what he said, but I didn't read his piece as requesting that people do civil disobedience, but acknowledging that it may be inevitable. Doctors will be faced with patients whose lives are at stake and will act, and a state that wants to might just prosecute them. And so he was anticipating the reality of this and asking organized medicine to use whatever resources it has to protect doctors who might find themselves in that situation. And in part, in response to, I think, his piece in the New England Journal, the American Medical Association's House of Delegates recently passed a number of resolutions. And that brings me to the second, I think Ash and I heard a second part to that question, which is what can doctors do? The AMA has, I don't remember all the things they passed, but a couple of them were that they were pledging that their own legal team, which is pretty substantial at the AMA, would come to the help of any doctor who was so prosecuted. So that's one thing. A second thing was that they discussed paying the costs of residents who would have to move at least temporarily to another state to get abortion training if they were if their residencies were in states where it was illegal. So those are two ideas.
Yeah, and those are great ideas. I'm reminded that we got the right to birth control because, of course, Planned Parenthood medical staff decided to defy the law and to prescribe birth control to people in contradiction to the Connecticut law. But the penalty for doing it was not going to jail. It was a fine, a relatively modest fine. And I think that those kinds of acts of rebellion as a way of creating test cases to get to the courts to try to change the law are an incredibly venerable and important kind of civil disobedience. But again, I'd hate to see doctors at this point take on the risk of imprisonment, jail, at this time.
Yeah.
Yeah.
I think that makes sense. Asha.
And by the way, it's often said that the main thing we all need to be doing right now is focusing on state lawmakers. So maybe the medical associations like the AMA could be helping to organize voters in states where abortion is illegal to go to the polls and vote against legislators and legislation that limits the right to abortion, unduly limits the right to abortion. We can all participate in that, and the heft and power of medical associations in this regard is, I think, inestimable.
Right. Asha?
Thank you. So switching away from kind of focusing on physician response, there are also a few questions about legal responses to Dobbs. So one attendee asks, is it possible to create a right to abortion stronger than the privacy arguments that are already in Roe that would convince textualists? And another asks more broadly if there is a legal strategy that you see as most effective in response to Dobbs.
So I don't think that there is an argument that would persuade textualists that there's a right to abortion. Almost by definition, I mean, what it means to be a textualist was actually something that emerged in the context of the opposition to substantive due process as applied in cases like Roe and other cases around progressive rights. So it would be highly ironic if people who were born of an opposition to Roe could somehow be persuaded using textualist arguments that there should be an abortion right. Because if you don't think that the idea of liberty and the idea of equality means liberty for women and equality for women around birth control and abortion, I don't know how one could persuade you otherwise through a textual argument, right? Because that is the textual argument, that those ideas are the source of our right to support women, is our abortion right that should be respected. Legal strategies. So what I just said about state laws, I think it actually was Joe Biden who, right after the Dobbs decision came down, pointed us toward putting our energies into affecting state law, which means that we have to have the right people elected as officials on the state level in the state houses. We have to use the referendum process in states where referenda like California are possible, and we have to push hard on those lawmakers to come up with laws that may be not the ideal abortion law, which for me would be no restrictions whatsoever on abortion, but maybe there can be some Roe versus Wade or Casey type compromises that give women a great deal of choice, but at the same time give the states the ability to exercise their right to some degree of fetal protection. So, legal strategies otherwise. I think that political strategies are the legal strategies. I guess I'm enough of a legal realist to think that law is largely politics. And so we need a Supreme Court, ultimately, that's going to overturn the overturning of Roe versus Wade. We should be fighting for that, fighting for judicial appointments, which means fighting for the right president, fighting for the right Congress, and getting into office someone a group of jurists who are going to see things differently. This could take generations. It could take 20 years. It could take 30 years. It took, realistically, it could take a while to reconstitute the court unless we were to engage in court packing. But I think I'm very much in support of those who want to focus on the presidency, on Congress, and on the state houses and state governors. Another thing too is that we can enact federal laws. Very recently, I think it was just this past week that the president announced that the Senate had approved laws that secured the right of interracial marriage and the right of gay sex. Now, just focusing on interracial marriage for a second, the very same jurisprudence that supports the Supreme Court's right to interracial marriage it's essentially the same as in Roe. Maybe a bit more equality focused, but the same 14th Amendment is being interpreted there. So and the same kind of core values are at stake. Making important decisions about one's own body, sexuality, and family. If that's a federal interest, the abortion right is also a federal interest. But keep in mind, before we had Dobbs, we had a Supreme Court case that held that the federal government could ban so-called partial birth abortions, namely dilation and extraction abortions, as a singular matter, which I found, we could talk about that one all day too, but there was a brilliant dissent in that case by Justice Ginsburg pointing out that even that restriction on abortion was an insult to women's autonomy and equality.
Wow, what an answer. Ashna, another question?
Yeah, and your answer really kind of leads us into this next question when you talk about values and liberty. So one attendee asks that, do you find it more tenable to discuss abortion on a national stage in terms of a reproductive justice framework, or more broadly through the framework of liberty and a freedom to pursue one's future? And so what do you kind of see as the overlaps of those frameworks or the differences between them?
And I realize that today I've been emphasizing the individual liberty arguments and not the social welfare arguments in favor of abortion, of which there are many. And Michelle Goodwin, who's on your board, Hastings board, has done some wonderful work underscoring the ways in which the right to abortion ties into women's health more broadly. Because we are talking about a healthcare issue. We're talking about a maternal health issue and a fetal health issue. She would emphasize the quite shocking rate of maternal deaths in connection with pregnancy and childbirth. She would emphasize the fetal mortality in relationship to pregnancy, and to the disproportionate number of African American, Native American, and Hispanic women who experience adverse outcomes from their pregnancies that they, of course, would not experience if they had access to medically safe abortion. Abortion is still a very, very, very popular medical procedure. Most Americans are in favor of some access to abortion, and the number of women getting abortions, ranges from around 600,000 to 1 million a year, as far as the Goodmaker and CDC data would tend to show. So we're talking about a popular procedure that's an important matter of health for women and their families. And so we need to underscore that the among the social justice issues is the women's health issue and the minority women's health issue. So we're not just talking about liberty for the sake of self-expression. We're talking about what it takes for women's health and what it takes to undercut the historical injustices and the disparities in health that are so prevalent in our country today. It's interesting to me that that the Clarence Thomas, our only male Supreme Court justice and the only Supreme Court justice who took part in the Dobbs decision, of course, wrote a dissent that was even stronger than Alito's opinion on nixing the substantive due process abortion argument. He would like to see abortion rights go, but also gay sex and gay marriage would be on the chopping block in his opinion. But how cruel was his decision? How cruel was that opinion? 80% of the women in Jackson, Mississippi, from which the Dobbs case emerges, are African American. 80%, and about 30% of Mississippians are African American. So our only African American justice on the court at the time, we now have two, but at the time we had one, our only African American justice basically said, I don't care about the health and welfare of the black women of Mississippi and of Jackson, Mississippi. I want to shut down abortion anyway. And the reasons that he offered were purely abstract interpretations of the law, which are not only in the minority in terms of his own colleagues on the court, but it was far in the minority in this nation. So I'm deeply troubled and upset by the fact that Clarence Thomas showed so little empathy for the health of the women of Mississippi and Jackson, Mississippi.
No. Ashna, anything else you want to bring forward?
Yes. So when we think about access to abortion in the Dobbs landscape, how do you see the role of medication abortion in this new landscape? On the one hand, we see cases of increased surveillance and legal risk, but on the other hand, it may be one of the easiest forms of abortion to access now. And so where do you see that kind of fitting into this new legal landscape?
Mm-hmm. I'm delighted to have lived long enough to see that medication abortions have become more acceptable to women and more popular among women. So women have in theory a lot of choices. They can have the surgeries. They can have the surgeries. They can have take the pill. They have choices. I'll just leave it there. But what we're seeing is that the states that want to oppose abortion rights are scrambling to try to find ways to make it unlawful to even use a medication abortion or to obtain the abortion pills for the sake of a medical abortion in the state. And although it may be easier to secret an abortion pill or process over surgical abortions, it's not a clear win for women, because they still may be subject to criminal liability if they go down that route. So we just don't know yet exactly how that's all going to pan out. But I'm glad that women have choices. I'm old enough to have seen us talk about birth control and Norplant and the abortion pills and D&E and DNX, and so anyway, then I would respond to the question by saying that question mark, we don't know yet the extent to which the abortion pill is going to be an alternative. Nor do we know really how much women might turn to I'm not sure how to put this, how to turn to do-it-yourself abortions. There was a huge push in the late 80s and early 90s for women to take on their own abortions, early abortions. And, we don't want to encourage unsafe procedures, but at the same time, I think we should all be thinking about ways in which we can make pregnancy termination safe and effective, and that may, in ways that might enable us to get around some of these harsh abortion laws.
I'm going to have to lead us now to a wrap, and I want to take the chance to end with one last thought. We have talked about a lot of principles and ethical norms like privacy and liberty and equality and social justice. There's one that we haven't mentioned that I think I want to bring attention to, which is pluralism. I'd like to be really clear that there, and I think you feel this way too, Anita, but respond as you will. That we're not really talking about we're not talking about whether abortion is right or wrong in a given case. I don't think we're talking about. We're recognizing that these are deeply personal decisions. The arguments across everything we've been talking about for the last hour really are about arguments about pluralism. Are we going to allow each person to make their own moral judgment? I mentioned this in the last webinar, and I think it's worth saying again. For years, the co-founder of the Hastings Center, Dan Callahan, was pro-choice, and his wife, Sydney Callahan, was pro-life. And they debated these issues throughout their marriage, and even edited a book that represented the wide range of views. So to me, what we've really been talking about is an erosion of pluralism, an erosion of the idea that we can support each other in making our own individual moral judgments. So I wanted to put that in the room before we have to say goodbye. Any last thought, Anita? We have about 60 seconds.
Well, I agree that the pluralist perspective is important, that there will be different choice. If women have a choice, there will be different choices made. And I think that's an acceptable moral reality for us. I care deeply about children and babies. Among my other activities, I mentioned Planned Parenthood, but I've been on the board of an organization in Philadelphia that helps new mothers and pregnant women with their need for medical care, diapers, baby cribs, and so forth. So that one doesn't have to be all or none in terms of how one thinks about these issues. There's room for caring about families, about babies, about the unborn, about women who are pregnant and their needs. There's room for all of that. But I think I agree with what I think you're saying, Millie, which is that maybe the optimal public policy is the one we had before Dobbs, which was one which rested the choice in the hands of individual women and their consciences.
Exactly. Well, that's a wrap then. This was enormously helpful and so insightful, Anita. It's even more than I expected, and I expected a lot. I want to thank you so much on behalf of the Hastings Center for spending this hour with us.
Thank you for letting me talk about these issues. It's hard to talk about, right? But it's very important to talk about it. So thank you.
Thank you. Thanks so much. That was
Thank you. Thanks a lot, Millie.
Yeah. Take care.
And as a reminder, a recording of this event will be available at www.thehastingscenter.org. So thank you all for joining, and thank you to Dr. Solomon and Dr. Allen for this discussion.